Hi, everybody. This is Janelle Matuszak from Bugby and Conkle. I'm one of the attorneys. I'm presenting today Workers' Compensation Year in Review. I'm going to talk about the big workers' compensation cases that have come out over the last year or so. We're going to start with a couple temporary total cases. I should say that I think that there's at least one case that was from the end of 18 that I stuck in here, but most of them are from 19. Pacheco is a temporary total case. Here, claimant was injured and he went off work. He had restrictions. He accepted a light duty job offer from his employer and worked in that position for 3 weeks. It sounds like from the case, all he was doing was sitting in the cafeteria and they weren't offering him anything productive to do. Claimant said all he did was sit in this cafeteria, nothing to do, and so he just stopped coming in. So when he stopped coming in, he stopped getting a paycheck, obviously, and he filed a motion for temporary total disability compensation. The commission denied his motion, finding he abandoned his position, the light duty position sitting in the cafeteria. So claimant asked for a rehearing, is how they put it in the case. He actually filed a request for reconsideration. If you're not familiar with that, so there's a district hearing officer hearing and a staff hearing officer hearing. And after that, if you appeal the staff hearing officer hearing, you might get a refusal order refusing to take the hearing to the full commission. You can file a request for reconsideration. And sometimes, rarely, maybe 3% of the cases, if it's a juicy issue, the commission will give you a third hearing. And sometimes it's right back at the regional office, or sometimes it's in Columbus. So that's what happened here. It's not clear where he had the hearing, but he did have a third hearing. What the commission said is he's capable of sitting in the cafeteria, and since he didn't come in and do that job, he's not entitled to temporary total. Claimant filed a mandamus action in the 10th District Court of Appeals, which is how you challenge an issue involving temporary total. 10th District said he could perform the job. Again, he could sit in the cafeteria. It was within his medical restrictions. But they said for the first time that this job offer in the cafeteria was not made in good faith. They said temporary total should have been granted. The company now filed an appeal into the Ohio Supreme Court, and the Supreme Court found the light duty position was within claimant's restrictions again. The court also said any light duty job offer has to be in good faith, and the commission should have made a determination on good faith. The 10th District should not have determined whether this was good faith on its own. It has to be decided first by the commission. So therefore, the Ohio Supreme Court issued a limited writ, and they ordered the commission to determine whether the company offered the light duty in good faith. So I looked back at the 10th District case because sometimes they give a little more detail, and there was WA put on display and people were looking at him and there was nothing for him to do. And the employer said that's not really true. The cafeteria is really close to the parking lot. I think he was on crutches. It didn't really go into great detail about what his injury was. So it's easy for you to get into the cafeteria, and that's why we had you sitting there. So the commission, the parties did talk about good faith, but the commission just failed to rule on it. There was a discussion about whether this work was in his restrictions, which I thought was funny because sitting in a cafeteria should be within almost anybody's restrictions, but there was a little confusion because there was office notes that said he couldn't do any work at all, but there were restrictions on the Medco 14. So I think the court had to decide which restrictions to use, and they kind of ducked that by just saying he could sit in this cafeteria pursuant to either one. So the court never really decided whether sitting in the cafeteria was a good faith job offer or not. They just decided that you needed to discuss that, you needed to determine that. And this is kind of unusual because usually we see good faith in a different context. So when a claimant can't return to their former position of employment but has restrictions, if the employer offers them a job within those restrictions, they either have to report to work or they don't get temporary total. They don't get paid. So you can't get temporary total if you refuse a good faith job offer. Usually the arguments about good faith are about the hours or the location. So if you offer your employee a light duty job offer that's an hour away from their house, that might not be good faith. If you offer them a light duty job offer that's third shift and they usually work first shift and they have children or whatever, that might not be good faith. That's usually what we see. We don't usually talk talk about good faith in the context of what they're actually doing. So that was a little unusual here. And again, they didn't really decide whether that was good faith or not. So I think it's okay to keep offering those kind of jobs, but just keep that in your mind about there might be an argument about whether that's good faith. So continuing on with job offers, the Mercy Health versus Industrial Commission. This is a funny case because we're only talking about 12 days of temporary total here. It gets a little confusing with the dates, but claimant had a treating physician assistant who certified restrictions on a Medco 14 beginning May 18, 2017. And so the company offered her a light duty position by telephone. They called her on May 22nd, talked to her attorney. Her attorney told her not to take the job. So the claimant called on the 30th, I think after some back and forth from her employer, and she said that she would not take the light duty job pursuant to her attorney's instructions. So on June 2nd, the company sent her a written job offer. It was the same job, they just put it in writing. Same job as they offered on May 22nd. Now claimant accepts it, and she returns to work June 6, 2017. So the only problem with that is what do we do with the period between May 25th and June 2nd? May 25th when she was supposed to return to work, and June 6th when she actually did return to work. Claimant requested temporary total during that time period, and claimant argued, I wasn't able to return to my former position of employment, and the employer did not give me a written good faith job offer, so therefore I'm entitled to temporary total. The commission said she's entitled to temporary total. They rejected the company's argument that claimant refused a valid light duty job offer. The company filed a mandamus action, and the 10th District Court of Appeals said no, she was not entitled to temporary total for that, I think it was about 12 days. The claimant looked at the code, 4121-3, the rule, 41-21-3-32, which requires light duty job offers used to terminate temporary total be in writing. And the court said that's incorrect because here the claimant was asking for a new period of temporary total. This was not an issue about terminating temporary total, and there's no requirement that that be in writing. So the rule cited deals only with the termination of TT. The court said for a new period of TT, you actually have to look at RC 4123.56, which provides temporary totals not payable when the employer makes a job offer within the physical capabilities of the claimant and does not include a requirement that the offer be in writing. So the court granted the request for writ of mandamus and ordered the commission to vacate its order granting temporary total and consider the validity and effect of the oral job offer. So they just sent it back and asked the commission to look at the job offer that was made by telephone, whether that was good faith and within the claimant's restrictions. The amazing thing about this is they went through all that for 12 days of temporary total. I'm not sure why they did that. It's really interesting because I haven't seen it separated out that way, but it makes perfect sense. So if you have a request for a new period of temporary total and you give the claimant a job offer, it doesn't necessarily have to be in writing. Best practices are that it be in writing because a telephone call, the claimant can say you said something you didn't. So the best way to document it is to put it in writing. I would say for a new period of temporary total, so if you have a claimant who is just going off work but has restrictions and you have a light duty job offer for them, you should call first, offer it to them, do just what this company did, and then send it out in writing, except for you should probably send it out in writing right away. So if you're arguing about a period between the oral job offer and the written job offer, it's just a very short one, but it's okay to make a job offer by phone if it's a new period. If claimant has been off work and then given restrictions, then it has to be in writing from the start. And I think it's just a quirk in the law that they didn't catch when they were writing the rules because it makes no sense to differentiate one from the other, but that's where we are. Okay, so still kind of talking about temporary total here. I'm going to move on to Reisinger, talk about voluntary abandonment. Just to kind of review what voluntary abandonment is, this is probably the most litigated issue and what we see the most changes in the law. The issue is voluntary abandonment. Claimant can only get temporary total if they're unable to return to their former position of employment due to the allowed conditions in the claim. If they can't come back to work for a different reason, they shouldn't be getting temporary total if it's not actually the allowances. So if the claimant quits their job and then they have surgery, they shouldn't be entitled to temporary total because they didn't have a job to return to anyway. Under the same theory, if the claimant does something that led to their termination for them to get fired, then they also shouldn't get temporary total. The way the law has developed, the test is something we call the Louisiana Pacific test. It's just, there's a case called Louisiana Pacific, and that's why we call it that. If there's a written work rule and violates, and it results in their termination, and they should have known it would result in their termination because it says in that work rule, then they're not entitled to temporary total because they were fired for an intentional act that they knew would result in them being fired. The reason why they're not working is the termination, not the injury. So here, there was a progressive disciplinary policy, and the claimant kept doing things and getting written up and eventually was terminated. First, claimant used the cell phone on the floor and received coaching. I'm not sure if this was a he or her, but I'm going to say her. And then she failed to follow the lockout tagout procedure and received a written warning from the company. Next, she failed to wear safety glasses and was suspended for 3 days. She came back and she wore her safety glasses, but she didn't wear the side shields on her safety glasses and was terminated. All 4 violations were after the injury, which is important for voluntary abandonment because sometimes there's different rules when you get terminated for whatever you do when the injury occurs. So we won't go into that with this because it was well after the initial injury. The claimant requested temporary total because she's off work now. The commission denied her request. They found she voluntarily abandoned her employment. They looked at the progressive discipline policy, so there was a clear written work rule that was violated, and it was clearly spelled out that so many violations would result in termination, and that was the reason why she was terminated. So claimant filed a mandamus action in the 10th District Court of Appeals. Court denied the mandamus action. They said, just what the commission said, the company followed the progressive discipline policy, and therefore this was a good termination, voluntary abandonment, no temporary total. But claimant said, I didn't know that this would result in his termination because it's not the first time he failed to wear the side shields. He said, I've come to work without these side shields before. I've never been terminated before, and now all of a sudden I've lost my job. I shouldn't have to forego temporary total. Well, the court sided with the employer here and said that there's no requirement that the claimant know further violation will actually lead to termination. The rule has to be in writing in such a way that the worker knew or should have known it was a dischargeable offense, which I think is a big victory for employers because I'm sure you all have situations where certain rules are violated and people aren't terminated, but then they're terminated later. This case says as long as it's there in the rule that they could be terminated and they know about it, that's enough for voluntary abandonment. You have to look at the whole theory, though, because it has to be, if the termination was not because of the rule violation, then it's not a voluntary abandonment. So if the claimant can convince the hearing officer that they were terminated because they have a workers' comp claim, and look, everybody else is doing it, but I'm the only one who got fired, the hearing officer could find the termination was due to the comp claim and not to the rule violation. So you have to be a little careful with that. I always recommend you apply the rules evenly, but if you have a situation where it wasn't always applied, you may be able to use this case and still get a voluntary abandonment. So I've got a second voluntary abandonment case, State Extra Stallion Oil Field versus Industrial Commission. This is a positive drug test. The policy said a positive drug test which exceeds cutoff levels established by the government or other reasonable standards will result in termination. So it's important to note on this one also, claimant was fired after a positive drug test, but the drug test was not right after the injury. It was not close in time, so we don't have that issue here. Company argued claimant voluntarily abandoned his employment because the rule said positive drug test would result in termination. Company filed evidence that the drug test was positive, but didn't file the level. So they didn't provide evidence of how much of the drug was in the claimant's system. And so the commission found the company failed to follow its own policy, which said the positive drug test had to exceed cutoff levels, and then there was no voluntary abandonment. So the company filed a request for reconsideration, and now they filed the missing levels. Now they showed his coding levels exceeded the baseline levels in a handbook, but the commission refused rehearing. So after the second hearing, If you lose, you can file a request for reconsideration. Like I said earlier, the commission does not have to hear it. Maybe 3% of the time they will, and here they just refuse to hear it, which is their right. So the company filed a mandamus action in the 10th District Court of Appeals, and the appellate court agreed with the commission that the company failed to follow its own policy, and submitting the levels after the SHO hearing was too late. So anytime you have a positive drug test, and usually we see this in a post-injury drug test, but I think this is just a random, but anytime you have a drug test, there's two parts. First, you have just the screen that says positive and negative for each substance, and the second part is the actual levels of the positivity of the drug. And regardless of what the issue is, you really have to file that, and it takes a little work to get that. A lot of times the hospitals won't want to give you the actual levels, and sometimes you may even have to subpoena it, but you're almost always going to need that to show how impaired they were. And when we're talking about, I won't go into this too much because this wasn't the issue in the case, but there is a doctrine, there's a code section where if the injury is due to an intoxication or under the influence of alcohol, the claim can be disallowed on that basis because it's not due to the work, it's due to the substance they're using. But you have to follow the levels because it also has in the code certain cutoff levels where you have to be on each individual drug. And if you don't follow the levels, and this actually happens an awful lot, where the employer will just file the positive drug test and think that's enough, and that's not enough to get a claim disallowed. Even the levels, you're also, in addition, you're going to need an opinion from a doctor who's looked at the levels and said this person was impaired and the injury was not caused by work, it was caused by this impairment. So even though this wasn't an allowance issue, it's just a good reminder that there's two parts to a drug test. You need that second part anytime it's an issue for workers' comp hearing. The next case is Fire. This is a loss of use case. And so 4123.57 covers permanent partial disability awards, which most people are familiar with. It also covers loss of use or amputation awards. Here, claim was additionally allowed for bilateral cataract syndrome on a flow-through basis as a result of long-term use of corticosteroids to treat an industrial injury. I can't remember what this injury was, but it wasn't an eye injury. It was just that it happened to be taking this drug resulted in the cataract syndrome. Claimant filed a motion for a 35% loss of vision award due to taking this drug. And claimant's attorney just filed evidence that prior to the injury, claimant's vision was 20/20, and then evidence that after the injury, the vision was 2100. So these are called Snellen fractions. So the claimant's attorney asked the commission to look at this chart here, and this is taken from the AMA Guides to the Evaluation of Fifth Impairment. This is the book that the doctors look at when they're assigning a permanent partial disability impairment. And if you look, like if I was in a seminar, I'd show it to you, but if you look at it under the US notation, if you look at the 2100, it's under the moderate low vision, and you kind of scroll over, it represents 35% visual acuity. So he said it was 20/20, now which is perfect, and now it's 2100. Look at this chart, that's 35%. The district hearing officer, and this hearing was in Toledo, looked at the table, looked at these Snellen fractions, and awarded 35%, which is a pretty significant award. Usually it's just thousands of dollars. Company obviously filed this would be an appeal here for loss of use. The SHO reversed it and said, you can't just file the chart and your vision and evidence of what your vision is. You need a doctor to say that the allowed conditions resulted in a loss of vision, and the loss of vision is 35%. You need a doctor to connect the dots. Claimant didn't like that, obviously, and filed a mandamus action. 10th District sided with the claimant and said there was enough there to grant the loss of vision award based on the chart. Company filed an appeal to the Ohio Supreme Court. The Supreme Court sided with the company, so it flip-flopped both ways and said claimant's evidence was insufficient to support the award for a permanent partial loss of sight. Evidence comparing pre-injury and post-injury visual acuity test results is not evidence of a physician's determination of its degree of impairment, and you have to submit medical evidence showing the degree of impairment. So if you happen to ever have this issue with a loss of vision, or even I can see this coming up with a finger amputation, which actually we see quite often, unfortunately. Don't just take the chart they give you, or if you see or a picture of the hand or the operative report. You actually need a doctor's opinion to connect the dots. And I think here the claimant could have easily gotten it. He just didn't. And since it was granted at the DHO, he must have felt pretty confident and didn't go and get it at the SHO. So it's a pretty big blow for the claimant there. And just for employers, it's a good reminder not to just automatically grant the award, that you have to make the claimant do the work and get a doctor's opinion on the impairment. Because you never know, maybe for some reason they'll have trouble getting it. Okay, moving on to AWW, one of my least favorite topics. Tantarelli, quick review on AWW, stands for average weekly wage. And claimant is paid temporary total and permanent total is based on their average weekly wage for the year prior to the injury. So in most cases, you look at what they made for the 52 weeks prior to the injury, add it up, divide by 52, whatever that number is, that represents the average weekly wage for the life of the claim. Temporary total is 66 2/3% of that average weekly wage. Permanent total is the same thing. So there are circumstances where a claimant can argue that that number is not fair and the commission should recalculate, give them a higher number so they make more money. Most often what we see is claimant didn't work a full 52 weeks before their injury. Claimant only worked 40 weeks. So maybe the 12 weeks claimant was off work, he was downsized or something and spent 12 weeks looking for work and it wasn't his fault. If claimant can show that he wasn't working and it wasn't his fault, then those can be excluded from the calculation, and you can see how if you divide the number by 40 rather than 52, you're going to get a higher number for the claimant. Other excuses are medical. If claimant couldn't work because of medical reasons, sometimes medical of a child or a parent they're taking care of, it's almost always. So here, a claimant's AWW is only set at 22.26. He only worked for the company for 3 weeks. Company didn't have any other information. And it's not just the weeks worked for the company. Had he supplied wages for a different employer within that year before the injury, that goes into the calculation as well. Here they took the total of what he made over 3 weeks and they divided by 52 and came up with 22.26. Claimant filed a motion asking for it to be recalculated. He wanted a higher number, but it went to hearing and the commission denied the motion. And they said he failed to provide proof he was unemployed for reasons outside his control and looking for work in the year before his injury. So just what I talked about, if he could show that the reason why he wasn't working was not his fault, beyond his control is what they use in the code, then those weeks would have been excluded. And had he taken his actual wages and just divided by 3, he would have obviously come up with a much better number. 2 years into the claim, he files another motion to recalculate his AWW, and this time he says, please recalculate based on special circumstances. So special circumstances is something else besides out of work beyond their control, another reason why it should be recalculated. Sometimes, so it could be something like the year before I was injured was just a really down year. I work on commission. I almost always make more money than that, so that's not fair. Or it could be that there's a tender years doctrine that kind of goes in that, or it could be that I have more money and my potential for earning is so much more that you should recalculate it. It could be I was a student, so I only worked part-time, but now I'm working full-time, something like that. Here, the claimant said he could only name 3 employers where he applied for work. He did some miscellaneous work buying and selling car parts and hauling items to scrap yard, but he didn't know how much he made. He didn't have any documentation. So this is a year before he worked. But also his special circumstance argument was, I made more money 10 years prior to my injury because then I owned my own business and then I ran a business again the year after my injury. So therefore you should use the special circumstances to show I should be making more money. The motion was denied due to res judicata, and res judicata is basically a lawyer term. It means this issue has already been heard and we're not going to adjudicate it again. The employer is entitled to some finality, but they also looked at the merits of the motion and said there's no special circumstances here. So even if it wasn't already heard, already res judicata, we would have denied it anyway. Claimant filed a mandamus action, and then it was appealed to the Ohio Supreme Court. It was denied all along. The Ohio Supreme Court said the motion asking for recalculation based on special circumstances was res judicata. The court noted the first motion just asked for recalculation without a basis, and did use special circumstances language in their motion, though. So the first motion just asked for recalculation of AWW. The SHO said there wasn't enough proof that he was unemployed for reasons out of his control, so therefore there's no special circumstances. So they kind of mixed the two together. And so the court said because the first motion didn't specify the reasoning, everything was on the table, and so it was res judicata. Had the claimant just filed the motion saying, and spelled it out in the first motion and said, please recalculate my wages because I was off work due to issues beyond my control, then the court said it might not have been res judicata. Then he might have been able to come back 2 years later and try a different theory, special circumstances. Going back, the 10th District in the middle actually denied the writ based solely on the failure to establish special circumstances. They said there were no special circumstances address res judicata, but every court that addressed the special circumstances said it shouldn't be raised. So this one is really more a lesson for the claimant to be real specific on your motion, but all the courts said there were no special circumstances anyway, and he was stuck with that $22 AWW. So moving on to State Extra Polarzik versus Geauga County's permanent total issue. This one involved, there's a report from Dr. Grunfeld. This is a bureau report. It looks like, not spelled out really well, but it looks like this was a bureau report on MMI or a different issue, not on permanent total, but it was helpful for permanent total. So claimant and argued it along with his application. So Dr. Grunfeld said 3 things that were issue. First, claimant's mental health issues likely prevent him from returning to his former position of employment. Claimant is unlikely to thrive in a moderate to high stress job setting and is more likely to work in an office where there is less stress to trigger his depression. And I believe he may be able to manage a vocational rehabilitation program. Total disability compensation was denied, and claimant filed a mandamus action. And a couple things to note, Dr. Grunfeld was asked whether claimant could return to his former position of employment, not asked whether he could perform any sustained remunerative employment. So permanent total disability compensation is lifetime benefits, and it's only for claimants who can't do any work at all. Temporary total is when temporarily the claimant cannot return to their former position of employment. Permanent total is when they can't go back to do any work, not even light duty. Then they can get lifetime benefits. So I believe the reason why Grunfeld was asked whether he could return to his former position of employment is because it was actually a temporary total exam that had some good language in there for the permanent total. So Dr. Grunfeld never said whether he could perform any sustained remunerative employment, just that he couldn't go back to his old job. But the staff hearing officer denied the application based in part on Dr. Grunfeld's report, because Dr. Grunfeld also said claimant is more likely to work in an office where there's less stress to trigger his depression. SHO took that as claimant's able to work in a low-stress job. So the claimant filed a complaint for mandamus in the 10th District Court of Appeals, saying the commission abuses discretion by relying on Dr. Grunfeld's report to deny PTD. He didn't even really address the issue of whether he could do any work. That was a temporary total report. And the 10th District said the report's ambiguous. It's not clear whether claimant could not do any work or whether he just couldn't go back to his old job. And they asked the commission to look at this again without relying on Grunfeld's report. Actually, the company didn't like that, so they appealed to the Ohio Supreme Court. Supreme Court looked at Grunfeld's report and the decision. And they said the statement that claimant was more likely to work in a low-stress job, not really enough to clear up the ambiguity. That's what the company said. The company obviously argued Grunfeld's report was fine, it could be relied upon, even though they say that he can't return to his former position, talk about he could work in a less stressful job, and that should be enough, he could use the report. The court pointed out that Grunfeld did not say he could work in a low-stress job, he just said that he was more likely to work in a low-stress job. And the 10th District Court of Appeals order was affirmed. It's sent back to the commission for decision excluding Grunfeld. It's sort of interesting because the permanent total was denied not solely based on that report. The claimant had a separate report. The company had a separate report. It was based on multiple things, but the claimant really picked up on this report from Grunfeld to appeal this into court and try to use that as a basis for getting another hearing, which worked. They did get another hearing on the issue. I'm not sure what happened after that. But on permanent total, sometimes easy to find these little ambiguities to try to get another bite at the apple. So I got another permanent total case. This one is Mignella. When you file a permanent total disability application, the claimant has to include medical evidence from their doctor, and their report always says they can't do any work, almost always. And then the company's obviously entitled to their own exam, and the Bureau has an exam. And here the state doctor said claimant could work light duty. Cases, if you can depose the state doctor, you can also ask if you can give them written interrogatories, ask for further clarification. It's not used very often, mostly because it's almost always denied. But there are times when the commission will allow this, and they allowed it here. And the claimant's attorney did a good job. They got the state doctor to admit she didn't examine claimant according to the AMA guidelines. And the reason is the doctor said claimant could work light duty but can't stand or sit for longer than 15 minutes. And there's a definition in the rules about what light duty means, what sedentary work means, and that doesn't jive with the definition. So you can't say she can work light duty but also cannot stand or sit longer than 15 minutes. Doctor admitted didn't examine according to the AMA guidelines because she didn't fit that light duty into those guides. So an SHO issued an interlocutory order referring the application back to the commission to schedule a claim for a second exam. And it doesn't look like the company even asked for this. It wasn't real clear, but the SHO said there should be another exam because this one is no good. Claimant refused to go to the second exam. They wanted the commission just to hear it without that. Kind of rare to see. This is a good report for the company. If the claimant can work light duty, that really opens up a lot. You can find a lot of light duty jobs typically that a claimant can do. So if that is thrown out, claimant's in a much better place and didn't want any exam. So the SHO suspended the PTD application, said we're not going to hear it until you go for an exam. Claimant filed an action in the Court of Appeals for a writ of proceedendo. I've never seen this in workers' comp, but it's asking a higher tribunal to tell a lower tribunal to do their job, to look at the issue. And so that's what they did. They asked the court to send an order to the commission ordering them to adjudicate the application for permanent total disability and find that she's not required to go to another medical exam. The court looked at Ohio Administrative Code 4121-3-09, which says the commission can at any point in the processing of an application for benefits, not just PTD, but any benefits, require the injured worker to submit a physical examination. When it comes to PTD, additional examinations are only permitted when necessary or helpful to determine PTD. PTD is permanent total disability. They said there's no conflict with 4121-3-34A, which requires timely adjudication of PTD applications. So what the claimant was arguing was this rule requires timely adjudications of PTD, and a second examination would delay the whole process, and now you're in violation of the rule, and so I shouldn't have to go to second exam. And then the claimant acknowledged there's a rule that says they can ask for exam at any time, but said those were in conflict and asked the court to figure it out. The court said the biggest delay is caused by this mandamus action. If you would just go to the exam, it would have been done with this. And they're not in conflict. You could still have another exam and still be a timely adjudication. Obviously, the Bureau is entitled to an exam, so she had to go back and do her exam before she could have her permanent total disability compensation application reviewed or heard by the commission. I just have one more case, Payne versus ODW Logistics. This is a litigation case. The issue was the allowance of major depressive disorder in the common pleas court. One day before the trial, claimant dismissed the complaint. It's written down court appeal, but technically it was the complaint that was dismissed, which results in the appeal being dismissed. But so claimant dismissed her complaint one day before the trial, and then the court issued an order disallowing major depressive disorder. And if you're interested, the reason why this happens is, so the claim was allowed at the commission, and the company appealed it into court. Even though it's a company's appeal, the company files a notice of appeal, and then the claimant has to file the complaint, and the company has to answer. So it's just like regardless of who wins, claimant always has to file the complaint. So if the claimant dismisses their complaint, it's like it was never filed. And if the company has filed an appeal and claimant never answered, then they win. So the court issued an order disallowing the condition because it becomes a lack of prosecution issue. But the company was obviously and understandably upset because claimant waited till one day before trial to do this. And if you've ever had anything in litigation, you know, like the 2 weeks before the actual trial or the month before the trial, is when you have depositions of doctors and there's a lot of activity trying to get ready. It can be expensive. So if claimant had meant to dismiss, they should have let the company know sooner so they didn't have to have all this expense trying to get ready for trial. The company files a motion for sanctions under RC 23.51 and Civil Rule 11, which I will explain a little more in the next slide. But the court dismissed the motion without a hearing, and then the company appealed to the 10th District Court of Appeals. On the issue of sanctions only, they're saying that claimant should have to pay a monetary amount to compensate the company. So there's two provisions you can ask for sanctions. 23-2351 says any party adversely affected by frivolous conduct may file a motion for an award of court costs, reasonable attorney's fees, and other reasonable expenses. And they define frivolous conduct as making allegations or other factual contentions that have either no evidentiary support or not warranted by the evidence. Rule 11 allows the court to award attorney's fees if a party willfully signs a document he or she knows is not supported by good grounds. So the company attorney was really upset that it was dismissed at the last minute. If you look at the two code sections, they kind of say the same thing. So to fashion this into sanctions, the company argued that, so if you look at the middle one, claimant was found on surveillance doing physical activities he said he was unable to do with his left hand and arm. TTD was terminated. Temporary total was terminated in part based on the surveillance video, which was sent to the claimant's doctor. And because he could do things he's saying he can't do, temporary total was dismissed. And if you're wondering what the heck that has to do with major depressive disorder, so the major depressive disorder is based on a theory that claimant is depressed because he can't do things he can normally do. They have surveillance video showing that's not true. He's actually pretty functional. So the company attorney argued that the whole complaint, the whole argument that he has major depressive disorder was frivolous conduct because obviously he's functional and not depressed because of that. In any event, the appellate court said they were very careful not to say that sanctions should have been awarded. They didn't look at the merits. They just said, the trial court should have had a hearing on this issue. And the trial court did say it was unprofessional to wait until the last minute to dismiss, but since there's no willful conduct and it doesn't rise to a violation. When the company attorney appealed to the appellate court, they argued they were entitled to a hearing on the issue, and the court agreed. Said, yes, you were entitled to a hearing. And they had the hearing, actually, I think it was December 16th. Yeah, since I did this. So the hearing was held December 16th, and the court issued an order, just came out this week, I think, and it was the same result. The court said, now we've had a hearing. It's not nice, basically says, it's not nice to dismiss the day before trial, but it's not sanctionable. Unfortunately, it would be nice if they granted sanctions. And they said this case may have been weak due to the claimant's functioning and the things they found on surveillance, but it certainly wasn't frivolous. The claimant still had an argument that he had major depressive disorder due to the loud physical conditions in the claim. And to find it was frivolous, the court would almost have to say that, the whole action was ridiculous, that the claimant had no argument that they had major depressive disorder, when all along the commission had allowed it. So that was a pretty tough argument to make. So the court ultimately denied the sanctions in this case. And that got you all caught up with 2019 All the Important Case Law. Thanks for listening.